I will call the committee, the Judiciary, Finance, and Civil Law Committee to order. And the first order of business is approval of the minutes from January 21st. Representative Steer, have you had an opportunity to review the minutes?
I have, yes. The minutes look good, and I move to approve them.
It has been moved to approve the minutes. Any discussion? If not, all those in favor, please say aye.
Aye.
Opposed, same sign. The minutes are approved. What I would like to do, first and foremost, folks, you should have a handout in your packets for the committee rules. And I just want to highlight a few of those for you. As you know, there was some disruption in one of the committees this week. And so I will be highlighting some of these rules that we need to pay really close attention to, the ones that are really kind of over and above what boilerplate rules might be. First of all handouts must be provided to the committee administrator by 12 p.m. the day before a scheduled committee hearing. Secondly, individuals wishing to testify before the committee should notify the committee administrator, our lovely Ms. Mantefel here, by noon the day before the scheduled hearing. And thirdly, all substantive amendments must be received by the committee administrator by 4 p.m. the day before the scheduled meeting. So that's not a 24-hour rule even, it's less than that. So if you have any last-minute ideas, I guess we're going to entertain them here. So, and then I just want to emphasize this last one. Signs, noise, or demonstrations that disrupt the committee's work may result in removal from the hearing room. And I just want to let folks know that we will operate with decorum in this committee. And if you come here and you start raising chaos, that you will not be given an audience for that. So with that, are there any questions on the committee rules? All right. My understanding is we don't really officially have to adopt those, but we will be sharing those with the entire House of Representatives. This morning, we have the privilege of hearing from the State Guardian Ad Litem Board. And so I would ask those testifiers to come to the table. We have Tammy Baker Olson, the State Program Administrator, with us. And she is here to give us a presentation so that you all understand what they do, the good work they do, and I believe they have a budget request that they're going to go over as well. So welcome to the committee. Please state your name for the recording and go ahead with your testimony.
Thank you, Madam Chair and committee members. My name is Tammy Baker Olson. I'm the Guardian Ad Litem State Program Administrator. So I want to start by thanking you for the invitation. It's a really timely invitation. We had our first Guardian Ad Litem Day on the Hill yesterday, and so many of us got to interact with many of you. So we're coming off a lot of excitement around that. So thank you for the opportunity. Before we talk about why we're all here, the budget, I wanted to give a program overview of the Guardian Ad Litem program. So I would start with our board. So it is the Guardian Ad Litem Board that administers the State Guardian Ad Litem program. Our board consists of 7 members. 3 of those members are appointed by the Supreme Court and 4 of them by the governor's office, by the governor. So our board membership consists of, per statute, 1 former Guardian Ad Litem, 2 attorneys, 1 public member, and at least 3 members from judicial districts other than the 1st, 2nd, and 4th. So what do we do? The Guardian Ad Litem role was established in 1974 with the enactment of CAPTA, the Child Protection and Child Abuse Prevention and Treatment Act, CAPTA. It's a federal law. We are both federally and state mandated by law. So the role of the Guardian Ad Litem, we're an independent voice representing the child's best interest. Guardians Ad Litem do not function as attorneys on cases. We do not represent children, and we do not provide direct services to children. What we do is help ensure children have their primary needs met and that the court has information to rule confidently. So this means guardians ad litem conduct interviews and observe children and significant people in their lives. They review social services, medical, school, psychological, and criminal records and reports, and attend meetings with a variety of professionals. And the program's busy. We're active in all 87 counties. We have 243 employees, currently 15 volunteers in the 4th Judicial District, Hennepin County. In 2024, we advocated for the best interests of over 12,000 Minnesota children in both child protection and family court proceedings. We attended over 30,000 court proceedings, and that included, our advocacy included representing over 1,500 Native American children on Indian Child Welfare Act cases and 1,600 children in family court. And finally, we filed court reports in over 16,000 court hearings. So the org chart before you depicts all of our staff statewide. So we currently, as I said, have 243 staff. We, in the last few years, we successfully combined management of 6 of our 10 judicial districts. So the first and second, 6th and 9th and 7th and 8th are managed by one manager. Combining those districts, we realized some efficiencies in doing so. You'll notice in our org chart, we have an independent family court division, which was developed in 2020 as a result of a 2017 NCSC evaluation. And we also have an independent Indian Child Welfare Act division. Our ICWA division, we're very proud of our ICWA division, is regionalized and specialized statewide. Recent division highlights include the completion of an ICWA MIFPA policy manual, as well as a foundations training with UMD Tribal Training and Certification Partnership. If you scan the QR code on the presentation, that'll bring you directly to that manual. Our staff worked very hard, so feel free to check that out.
What does that stand for?
The QR code?
No, the ICWA.
Indian Child Welfare Act.
Okay, thank you.
And MIFPA, Minnesota Indian Family Preservation Act. The Guardian Litem Board is committed to addressing racial disparities within the child welfare system so that all families and children in the state of Minnesota receive equitable outcomes concerning child protection matters. So all this incredible effort starts with extensive training. Guardians ad litem are professionals with diverse backgrounds who have wide-ranging training and education in advocating for children. They're required to have knowledge and advanced training in disciplines such as child development, chemical health, mental health, racial equity, culture competence, court procedures, state statutes, community resources, and the list goes on. We are not without substantial challenges. Our inability to provide a competitive salary has created significant challenges with recruitment and retention of professional experienced advocates. Staffing challenges have caused delays in case assignments in some areas of the state, thereby delaying crucial decisions regarding child safety and stability. A comparative wage study was completed in fiscal year 23 and updated wage study in fiscal year 25. Both revealed inequity in pay for guardians compared to other in similar roles, impacting recruitment and retention of qualified and diverse hiring pools. While guardians ad litem position descriptions are notably similar to child welfare workers, forensic navigators, and dispositional advisors, a guardian ad litem earns significantly less with a starting wage of $23.12. That's the chart that you see on the screen are those comparisons. Even more striking, entry-level jobs at Amazon are near the starting wage for guardians ad litem. So our budget. The current biennial base budget for the Guardian Litem program is $45,630,000. Payroll consisting of 84% and operating expenses 16%. The Guardian Ad Litem Board seeks $16,365,000 to fund mainly an increase in compensation and unavoidable health insurance premium increases. an increase in operating funds by $1 million yearly to meet the increased transportation and inflation costs. We do a lot of driving, a lot. And then finally, $476,000 to grow and strengthen the volunteer program. Each year, thousands of children depend on the expertise and dedication of Minnesota Guardians Ad Litem to provide the court with objective, child-focused recommendations. The impact of the Guardian Ad Litem program extends far beyond the courtroom. By advocating for children, holding the system accountable, and helping to resolve cases effectively, Guardians Ad Litem play a pivotal role in breaking cycles of trauma and strengthening child well-being. And at this time, I'd like to open it up for questions.
Steer.
Thank you, Madam Chair. So it's my understanding that the Guardian Ad Litem, they drive their own personal vehicles to wherever they have to go, and then they put in for mileage?
Representative Steer, that is the case for the majority of Guardians Ad Litem. We have implemented fleet vehicles in some of our, for cost efficiencies, in some of our larger destinations geographically, so in the north and in southern Minnesota. But for the majority of Guardians do claim mileage, yes.
Okay, and then,
Representative Steer.
sorry, so a normal day would be 200-300 miles on their personal vehicle, or just give me an average?
Ms. Baker Olson.
Sorry, Chair. Representative, that is for, that wouldn't be uncommon, especially for our outstate, our greater Minnesota Guardians Ad Litem.
Thank you.
Representative Hudson.
Thank you, Madam Chair. Could you describe how the role of Guardian Ad Litem interacts with the role of a child's attorney? In particular, I'm interested in the concept of best interest, how it's determined, and what role a child's desires or preferences play in, or how they're weighted in making that determination.
Ms. Baker Olson.
Representative, according to our roles, a child, I'm assuming you mean a child in the child protection system who has an attorney. That attorney is there to represent the child's best interests. That can be very different to what is in the best interest of a child. So the interaction with, it's very important that a guardian ad litem understands what it is a child desires as an outcome in the court proceeding and in their current situation. It can differ. So if we're all staying in our lanes, the attorney for the child is going to represent the attorney's best interest in court, whether or not it's in their best interest.
Representative Hudson.
Thank you, Madam Chair. You'll forgive me for it seeming clear as mud. And I'm coming at this as a relative layman to the judicial system, so I'm genuinely trying to seek an understanding of where how those lanes are defined. Like if we're going to use that metaphor, there's dash lines to show us which lane is which. So when we're talking about from an attorney's perspective, whose client is a child in this system, how their view of or what their responsibility is in terms of representing the best interest of that particular child, how does that differentiate itself from what a guardian ad litem is attempting to discern as the child's best interest, or however those phrases were inverted?
Ms. Baker Olson.
So I don't want to be redundant, but that they can often be different. So we wouldn't want our own children to always have their desire be met, right? So it's about gathering information. However, the attorney is there to represent what it is the child is saying they want in court. That can be different than what a guardian ad litem is going to represent in their recommendations to the court. Ultimately, it's up to the judge to decide.
Representative Hudson.
Thank you, Madam Chair. So just to summarize, and you can tell me if I'm getting it right or wrong, the attorney's job is to basically be the voice of that child, whereas the guardian ad litem's role is to, in a quasi parental role discern best interest, taking into consideration that voice, but also making broader judgments about whether or not circumstances are appropriate for the child. Does that
Ms.
make sense?
Baker Olson?
Representative, I would agree with the statement, other than quasi-parent. That was the only thing I would.
Sure.
Yep, that is correct.
Thank you.
Thank you. Representative Duran?
Thank you for coming here and helping us with this. I think your program's good and necessary. Now, back to what Representative Hudson was talking about. You look into more of the personal needs of the individual. Is that what I'm gathering here? The juvenile instead of the criminal side of things? You look at more of the psychological and make sure that they're getting the needs that they need. Is that what you're saying here?
Ms. Baker Olson?
Representative, Chair, so the majority of the cases that we're assigned to are child protection cases. And so what we do is we speak to all of the collaterals in our independent investigation. So we gather all the information about the child, talking with the school, their therapist, if there is one, their doctors, depending on the case. And then we come up with what we believe is in the best interest of the child in that recommendation. I'm not, if there's a specific question about a criminal, the criminal case, I'm not quite clear on the question about the differences between criminal.
Representative Duran?
Back to what Representative Hudson was saying is that there's a distinct difference in the criminal side of things, what the lawyer would handle, and then there's the personal side of things, the making sure that you're getting the best interest on the personal side for the child. That's what I'm trying to say here, is that you make sure everything's lined up on the best interest of them on like housing needs, psychological needs, therapy, everything else, right? Like you help organize all that stuff and get that stuff organized for the child. Is that what you're saying?
Ms. Baker Olson?
Representative, yes, we gather information and make recommendations to the court on what we think is in the child's best interest in regards to their well-being, their education, their placement, if they are in placement, whether or not they should reunify with family. We speak to permanency needs in child protection cases. Yes, best interest is it's a broad definition, and depending on the case that is before the court, your independent investigation depends on what is before the court. So what are the findings and what needs to be looked into, so that determines who it is the guardian ad litem's talking with and determines what information they're gathering in order to make the best recommendation to the court, for the court to decide.
Representative Duran? Good. Before I go to Representative Engen, if you could just explain to the committee and the public what triggers you being contacted, what triggers a guardian ad litem being contacted? What are the circumstances? I know you mentioned Child Protective Services. Are there other instances where it's triggered? Does it have to be a court action? I'm assuming so. And then I think what we're getting at here with the questioning too is talk about maybe what the guardians do in relationship when there is an attorney assigned to that child. Do you work together with that attorney? What's your relationship with that attorney as you're doing your work? If maybe that will help clarify some of this.
Madam Chair. So we are appointed by the court. That's what triggers our appointment. And so once assigned, depending on the case, we get straight to work in who we speak with. We always talk with, if a child has an attorney, that is absolutely one of the collaterals. We call them collaterals. So depending on the case, children bring different collaterals to their situation. So whether that's teachers, we're always in conversation and in contact with the agency social workers, whether that's a child mental health worker, children's mental health worker rather, or their case manager. So we are always in contact with the attorneys and listening to what it is the child's attorney is hearing and from the child. Again, that's one consideration in the big picture. And so there's consultation with collaterals. I wouldn't say collaboration because we are independent and we have an independent voice. So one thing that Guardians of Litem are good at is gathering all that information and having an independent idea of what should be represented to the court. But it's a constant contact for the life of the case. That consultation with contacts happens, collaterals rather. And certainly the child's attorney is a part of that.
Thank you. Representative Engen.
Thank you, Madam Chair, and thank you for the overview here. Have you guys seen an increased caseload?
Representative Baker Olson,
Representative.
or not representative, Ms. Baker Olson.
It depends on what areas you're talking about. Overall, we haven't seen an increase in cases. We have higher needs for guardians in some areas because of vacancies, the turnover that I've referenced. Cases are pretty stable right now, statewide for us.
Representative Engen.
Thank you, Madam Chair. And I guess I'm just curious as to why that is, because we do know that there has been an increase in CPS services being requested. We've seen increased caseloads of child abuse and neglect. So I guess I'm just curious as to why that wouldn't also translate to a further need for guardian ad litems. Guardians ad litem.
Ms. Baker Olson.
I have no doubt that there's an increased need in child protection in general overall. I think agencies are working differently with families. So we're appointed once a case comes into the court and a child is in placement. You can work with kids differently in child protection. Not all kids go into placement. And so I support and understand that there is an increase in the need for funding for certain. Our cases have just been pretty stable. That could change tomorrow. It really could change tomorrow. It changes month to month.
Representative Engen.
Thank you. I appreciate it.
If you could, what's the average caseload per guardian, if you have an idea there?
When we've ran, Chair Scott, when we've recently run the numbers, our average, so you can have a statewide average, and you can appreciate this. So we have higher caseloads of 20, 24. Not everybody is at 24. When we've run the average, that's where we were, an average of 24.
Okay.
Some of those lower caseloads, when we have new staff that are brought into the program, they have lower loads that affect that number. So 24 is an average.
So if there are 2 or 3 or 4 children in one family, is that one case or is that 4 cases?
That's one case.
Okay, perfect. Representative Engen has a follow-up.
So sorry, just one more quick question here. In the public safety space, we kind of talk about recidivism and the likelihood that somebody who enters into a system is more likely or less likely to enter back into that system. Looking at it through the lens of guardians ad litem, what is the likelihood, or do you guys have any data that would suggest that, there's hardcore evidence to prove that what you guys are doing is making sure that that child is in the most healthy and safe environment over the long run, rather than needing those services again in the future?
Ms. Baker Olson.
Representative. So in the child welfare world, we call it that reentry. And reentry it's a hard number to get at because of all the players that are involved in a child and family's life. So you've got the social worker, you've got a children's mental health worker, you have us, you have, so there's so many players prevents reentry it's a really tough question. It's something that we're looking at as a program, how to look at our qualitative and quantitative data and determine like outcomes. So that is something that we're looking at as a program. It's just the challenges. I'm not going to say it's impossible. The challenge is there are so many players that how do we determine that we were the one that made a difference on that case? We have a lot of qualitative data that says we have made a difference. We have in our packet that we had sent out yesterday, we have a letter from a youth, and we have multiple testimonies and hundreds of testimonies from youth who've said you made the difference. Quantifying it's a little bit challenging, but something that we're looking at so that we can support hearings like this.
Representative Rarick.
Thank you, Madam Chair. So I was looking at the history, and in 1975, we basically enacted that we have to have guardians ad litem because of what happened federally. Then from 1975 all the way until 2010, there wasn't an official board. There wasn't the guardian ad litem board. And in 2010, we established the board. Now, I came into the legislature very quick after that, and I remember those conversations in this committee. I believe Chair Scott was in that committee as well. And we talked about sort of this transformation of the guardian ad litem board and the guardian ad litems in a whole. Can you let us know what you saw as a difference? So before the board was there and after the board was there, I have some memories of some things, but I wanted to hear what your thoughts were about how it functioned after the board was established differently.
Baker Olson, if you're around for all that.
Thank you, Chair and Representative, for your question. So I was in the program when we were in the branch as a manager many years ago. I've come back to the program. I've been back now 6 years. So I was both pre and post board. I think that, we have more independence as a board, having a board administer the program, which has been, we've made some really great changes. In the 2017 OLA report, there were, I want to say 32 recommendations. I'm bad with numbers. Many of them have been acted upon. The specialization that we've done as a program with our divisions, having a juvenile division, an ICWA division, and a family court division, has advanced our program and our advocacy. I think we could have done that under the judicial branch. It just would have taken a lot more time, probably. We're more nimble as a board. We have a lot of support from our board, and our board members have been people who understand the child welfare system, and I think we've really benefited from that. We've always, when we were in the branch, we benefited in ways as well. But one unique difference, having a board govern us, is having a focus on child welfare and child protection and all the issues that it is that guardians ad litem work with every single day. When we were in the courts, we were housed, many of us, I was a manager in the first district, housed in district administration. I felt like a fish out of water oftentimes. Now there's more of a focus on child welfare and child outcomes. That I think that is something I think that we've benefited from. I haven't really thought about it until you asked the question in that way, but for sure that would be my response.
Chair Rarick.
Thank you, Madam Chair. So I was hoping to hear something like there were better outcomes for kids, or, that's sort of the point of it. So I'm sure you meant that and all of that because that was your perspective on the inside. But one specific thing I recall in these conversations that we had in Judiciary, over a decade ago now, Madam Chair, was that this transition from primarily, or quite a few anyway, of volunteer guardians ad litem and moving them to be salaried. I don't know if you remember that, if you were a part of that, but are you seeing better outcomes for kids now that you have the vast majority, if not almost all, of guardians ad litem are paid? Apparently not paid well, but they're paid compared to when they were volunteer. I wonder if you have any insight there.
Ms. Baker Olson.
Chair. Representative, thank you for your question. I was here when we transitioned to an employee model. And for context, at that time, the large majority of the state worked with contracted guardians. I was actually one of those at one point as well. There were only large concentrations of volunteers in the 4th Judicial District and the 2nd. And so when you said we hired volunteers, the majority of the state actually hired contractors if they wanted to work as an employee. We did hire, I'm certain, I don't have that number, I could find it, I could get it for you, volunteers in the 4th and 2nd who were interested in doing that. Volunteers are motivated differently. Many don't want to be an employee. They're here to do this work in a different way, and again, motivated differently. So I'm remembering the second part of your question. So do I think there was better advocacy as a result? Was that part of the question? Absolutely, I believe there's better advocacy. We have a better handle on what it is. I wouldn't even say handle, it sounds disrespectful. Our supervision and support is different than it was when we had a large pool of volunteers and a large pool of contractors. We were told, I was also a supervisor at that time at one point, we were told you really can't, they're contractors. If you treat them like employees, they're going to say you're treating me like an employee, and it's a problem. So we have a much better support and supervision in place than we did before.
You good?
Yep.
Chair Rick. Before we go to more member questions, I know that in the last couple of years, there was some controversy over doing away with the volunteers all around. And I was very opposed to that. Representative Edelson, who is now no longer in the legislature, but she and I were very disappointed in that move, and I offered amendments in committee to reinstate the volunteers, and I understand that the volunteers are now back. Can you kind of walk us through what transpired to make that change back? Ms. Baker Olson.
Chair Scott, thank you for your question. Our board made a decision to go a different direction. And acknowledging that we had some work to do around how it is we support, train, and supervise. And so that is where we are now. We have a modest pool of guardians and an intention to strengthen and build upon that pool. That is part of our budget request that's before you. Supervision is key. It was on the program to have been supervising and offering the support in this really complex work. And we have a plan in order to do that and strengthen that program so that we can move forward with volunteers.
And I was down at your meeting in the vault the other day, and I didn't get a chance to see you, but talked to Ann, and just I'm very excited that that is back. I understand there's some training to do and whatever, but I've often said in numerous committees that we have a silver tsunami, as they say, across this country and in the state of Minnesota, and there may be some people that they have time on their hands, and maybe this is what they want to do is invest in these children. And so I don't want to take that opportunity away from those folks or the people that are already working with kids. So I'm really glad that that has been reinstated. Representative Hudson.
Thank you, Madam Chair. I wanted to take this opportunity to get your perspective on the impact of provisions like ICWA or the Indian Family Preservation Act, and in particular, and I'll go back and I'll read this document, this manual that you have to get a more robust, comprehensive understanding. But just since we have you here, your impression of how a provision like that impacts your work, and then how it compares and contrasts to the African American Family Preservation Act, that was recently enacted, and whether there are differences in those two, or if they play out kind of similarly.
Ms. Baker Olson.
Thank you, Chair. And thank you, Representative, for your question. Very important to our work. The Guardian Ad Litem program supports ICWA, MIFPA, now AFPA. We're in the process of training guardians ad litem to work cases as the agency's learning what that means for the work and how the work is different. We've been fully supportive of ICWA as a program. With the advancement of our ICWA division, we've advanced our work in that area. Our manager in our division has led the ICWA division, and we're working in ways collaboratively with tribes that we have never before since the division's been created. And so if I understand your question, the program fully supports it, and we'll move forward with training. Once we understand, we've done the preliminary training for AFPA, I would say the foundational training, and we'll learn together what AFPA means, specifically in the 4th and 2nd District where the pilots are taking place currently.
Representative, you good? Representative Bliss.
Thank you. Just a quick question. I first came in the legislature in 2017, and one of my constituents brought an issue with the Guardian Ad Litem program. And I guess the issue was that the Guardian Ad Litem had a personal relationship with the family on one side of the family, and was making recommendations that she didn't feel were right because they were weighted to the family or friend. What is the review process? If a Guardian Ad Litem has a conflict of interest or something like that, what is the review process to go through? Because I know she was having a very hard time getting kind of answers through the board.
Ms.
So
Baker
if you
Olson.
could just do the review process for me.
Ms. Baker Olson.
Thank you, Chair. Thank you, Representative, for your question. The conflict of interest popped right into my mind. If there's a relationship with a family, that should be reviewed immediately and not wait for the formal complaint process. We do have a formal complaint process, which is online on our website. And so that would not need to go to a formal complaint process. A call to a manager, supervisor, should have been responded to immediately if there was concern. We would have a conversation with the guardian about what that relationship, if there is a personal relationship, that we have no business being on a case that we have a personal relationship with the family.
Representative Engen.
Thank you, Madam Chair, and sorry for the exhaustive questions here. I think that everybody on this, in this committee is definitely dedicated to the protection of each and every child in the state of Minnesota, and that's why we're seeing you guys as such a unique and innovative tool and making sure that actually happens. One of the questions that I had after taking a look at your guys' website here, so you guys are permitted to propose statutory changes and rule changes, recommendations to the Supreme Court as well as the legislature. What recent statutory changes or policy discussions have you guys engaged in?
Ms. Baker Olson.
Thank you, Chair. Thank you for your question, Representative. Our board in, I would say probably the last 3 years, has taken a pretty active role, starting with forming a board advocacy committee. They have a specific committee that looks at any proposed legislation that has to do with kids. Now, that's a really broad, so any legislation that looks at kids that has to do with children, that was the first conversation the board has. How do we narrow down? Because there's a lot of proposed legislation related to children. Conversations that we've been a part of, we supported AFPA. We had conversations with licensing rules that were proposed last session. We were, I believe, formally supportive of the ombudsperson for foster youth. I'm going off of memory. Anything that connects with the children we serve, the board pretty routinely is looking at whether or not there should be a formal support of that legislation.
Representative Engen.
Thank you. And if you have a full list of the policies that you have supported, that would be extremely beneficial to us.
I will follow up with that for sure.
A question popped into my mind. You know, we hear a lot about human trafficking and that sort of thing. Have you seen an uptick in cases where the child that you're involved with has been a victim of that? I guess I'll leave that question there.
Thank you, Chair, for your question. I wish I had a manager or supervisor here right now. I would say it's been, that has been a consistent challenge for the families that we work with. I don't know about uptick. I would hate to commit to there being an uptick. But that it's a constant. It is a constant issue. I had mentioned that I came back to this position 6 years ago. I was in Ramsey County Child Protection as a manager prior to this. And I wish that there was a guardian here to speak to it.
Sure.
I guarantee that on any given caseload, that is a challenge that the youth is and family is working with.
Representative, Chair Rarick.
Thank you, Madam Chair. So I was just doing a little quick search, as I'm known to do, because when I was looking at the graph of kind of the wage study and comparison, when I looked at, first of all, the State Board of Competency Attainment is new,
It is new.
completely new. So it's a little, I wouldn't have picked that to put on here personally, but it is here. So then I was looking at the State Board of Public Defense, the dispensational advisors. So I just looked up, and there's a job posting right now in Hennepin County. And the salary range is $23.81 to $39.55. So, I mean, that's a job posting that was just posted. Oh, no, I take that back. That was a few years ago. So let me ask you, since this is old information, I see it's a couple years old. Since there is a range on this older posting, do you have a range? Because I'm sure that 33.45 isn't what every advisor makes from the State Board of Defense, but shouldn't it be a range, kind of like the competency board is, which is brand new, and that's a brand new board that will be, or excuse me, the competency attainment board, which we'll be hearing from. But since we're kind of comparing to the dispensational advisor at the Public Defense Board, in this old posting, it shows a range, and here it has just a one salary amount.
Representative, I can get you that range. We Googled that right before making that document, so that's the current, but I can get you the range for certain.
Thank you for that.
Okay, because I think it's a little, Madam Chair,
Any other member questions?
just a quick.
Oh, I'm sorry.
Just
Go
a
ahead.
follow-up.
I didn't hear you, sorry.
Thank you, Madam Chair. So the question is, I'm a numbers person. I want to see the facts in front of me, and I'd like to see like a current job posting of what the salary range is, because I'm thinking it's probably not completely accurate, because it's probably a range. But if you could show me where that information came from, and maybe also if you could provide to us something other than the Competency Attainment Board, which is completely brand new, that would be helpful too, I think, so that we can really compare apples to apples. Thank you, Madam Chair.
Thank you. I see no other member questions, and so I want to thank you for being here. Thank you for your presentation, and give my best to the folks that work with all these children and the hard work that they do, and the things that they have to be exposed to, quite frankly, as well. And again, thank you for being here, and with that, we are adjourned.